Okay, so we can get started. Hi everyone, welcome back. For those of you who don't know me, my name is Andreas. I'm a lecturer in legal and theory here at UCLan. I'm also a researcher for the Jean Monnet module, European Union Law and Governance in Populist Times. It is within the framework of that Jean Monnet module that this summer school is taking place. What I'm going to talk about today is based on a paper that I'm currently finalizing. So I do welcome any input, any comments you have. This session today is designed as a workshop, so I do expect to hear from you, questions, comments, anything that is unclear, anything that you'd like to discuss. You can at any point raise your hand and let me know, then we can talk about it. The same goes for everyone on the Microsoft Teams group. I'll be monitoring the chat, so if you write something in the chat, I'll be addressing that. If you want to talk, you can also use the raise hand function, and then I'll tell you your name, and you'll be able to unmute your microphone and talk. So what I'm going to discuss today is the rule of law, democracy, and the courts. Unlike other presentations that we've heard in the summer school, my presentation takes a different approach, right? So it doesn't look at a specific country, it doesn't look, well, not as much. It doesn't look at as much at particular cases. It rather looks at the more theoretical role of the courts within a democratic state. So we'll be talking about what we mean by the rule of law, what we mean by democracy, by democratic legitimacy. We're going to talk quite a bit about judicial review. And it is within the context of judicial review that I'm going to mention a few cases that we can discuss. So let's get started. Within the last few years, there has been intense interest in the rule of law within the EU, right? And in the European Union, there have been attempts to monitor compliance of state actions with the rule of law. There have been attempts to catch possible violations of the rule of law as early as possible and take steps towards that end. What I have here is not a complete list of the mechanism available at the EU level, it's rather an indicative list. So there are some mechanisms that are of a legal nature, right? Danuta yesterday talked about the actual use of those mechanisms, so I'm not going to go through that now. That would be repetitive. What I have here in the slides is the infringement proceedings, where we have the European Commission taking action against a member state for their possible violation of or action that possibly infringes on European values included in Article 2 of the Treaty of the EU, and therefore the rule of law, which incidentally is included in that article. And we also, of course, have the Article 7 procedure, the so-called nuclear option, where if a member state is found to be in breach, then there would be severe repercussions, right, including the withdrawal of political rights from that member state. And as Danuta mentioned yesterday, there are many obstacles to applying that procedure and seeing it through. If you want, we can talk more about the reasons why those mechanisms are not as effective as we would like, right? Complementing those legal mechanisms, we also have so-called soft law, right? Non-legal procedures that aim to open up a dialogue or an avenue of discussion between EU institutions and member states. There have been multiple mechanisms over the years. Most interestingly, last year, so it was, I think, November of 2020 that we have the publication of the first annual Rule of Law report. That was a comprehensive report that looked at the state of the rule of law Europe-wide with different reports for each country. September, was it? Yes, so it was September 2020. Yes. Of course, that is available online, so anyone can go to this to the website, to the European Commission's website, and find that report and find the report for specific countries. Now, one question we might be asking is, well, what has prompted that emphasis, that shift of focus to the rule of law? Danuta mentioned yesterday the Copenhagen dilemma, right? That even though complying with the rule of law is a condition to get into the European Union under Article 49 of the Treaty of the EU, there's no corresponding mechanism to check continued compliance with the rule of law within member states. And what we've witnessed in recent years, and this is this kind of goes back to the discussion we had last year in the last summer school about the rise of populist parties in Poland and Hungary. I should mention from the outset that Poland and Hungary are not the only culprits when it comes to violations of the rule of law. That's not true by a long shot, right? So different countries have been subject to action because of their alleged violation of the rule of law. The reason why I pinpoint Poland and Hungary is because these are two countries, member states of the EU, that for the past few years have had populist parties exercising political power. That's the reason why Poland and Hungary are pinpointed here. This has to do with the fact that in both countries we have populist parties exercising power, in Poland with the Law and Justice Party, and in Hungary with Fidesz and Viktor Orban. This is why these countries are selected here, and these parties, these populist parties, have undertaken action that attacks principles of the rule of law. Right? Certain conditions of the rule of law are undermined by certain actions. Now, I don't want to get into too much detail into these actions because Danuta did that yesterday very, very well with respect to Poland. I just want to point out that analogous problems arise in Hungary, where we do have an attempt by populist parties to exercise increased control over the judiciary. Right? So all these measures, from the lowering of the retirement age of judges, to the creation of a disciplinary chamber, to muzzle laws targeting the judiciary, all of these measures are aimed towards undermining judicial independence. They're aimed towards increasing executive influence over the judiciary, and therefore undermining the principle of the rule of law that the courts are actually impartial arbitrators. What we have is populist parties attempting to instill in those courts judges that are sympathetic to their agenda, so that the courts are no longer an obstacle in whatever those populist parties want to achieve. Right? So this is kind of an overview of the situation, the reasons why the EU is interested in looking at the rule of law, and a sample of the role of populist parties have played in creating this environment. Now, one thing that I want to discuss before we proceed is, I've already mentioned the concept of the rule of law. And over the past day or so, we've talked a lot about the rule of law. But it is by no means clear what we mean by the rule of law. And so what I want to do now is say a few things about the rule of law as a concept and the different conceptions of the rule of law. Maybe in the workshop later today, we'll be able to talk in more depth about this understanding of the rule of law. Now, broadly speaking, I think we can distinguish between thin conceptions of the rule of law and thick conceptions of the rule of law. The example that I have here up on the board is a famous book written by American jurist Lord Fuller. The book is called The Morality of Law. In that book, Fuller identifies 8 principles of legality, as he calls them. These 8 principles are, according to Fuller, necessary if we are to have a rule of law system, if we are to have a legal system at all. So what Fuller is saying is, as you can see, we have 8 principles of how to make law. Incidentally, he talks about failures to make law, but for our purposes that should suffice. Those principles include generality, public promulgation of the laws. The laws must be prospective, they must be clear, they must not be asking the impossible, right? So these are typical conditions we associate with a legal system, right? We cannot think of a legal system that only issues ad hoc laws, or we cannot think of a legal system that only issues secretive laws. Now, one interesting thing about this Lon Fuller's theory is that even though Fuller adopts a thick conception of the rule of law, because according to Fuller, these principles of legality, they have a moral component, right? They're not simply procedural, they have a moral component. That's why Fuller talks about the inner morality of law. There's a morality in those principles. Other theorists, such as Hart and Joseph Raz, they argue that those principles of legality that Fuller identifies are actually simply procedural. They're nothing more than procedures making a legal system more effective. So what Hart and Raz argue is that, yes, we can take those 8 principles of legality, right? There's nothing inherently moral about them. Even in Nazi Germany, they could simply decide to issue laws that are general, issue laws that are prospective, issue laws that are clear, and so forth and so forth. So a thin conception of the rule of law suggests that the rule of law is simply a matter of procedural requirements. It's simply about the process of making law and the process of applying law. Nothing more than that, simply procedural. And for us, it's not just that the rule of law is simply procedural, it's also that the rule of law is simply one value that a legal system could choose to have. Right? So this is the thin conception of the rule of law, we might say. Contrasted with these thin conceptions of the rule of law, we can think of thick conceptions of the rule of law. Thick conceptions of the rule of law say that it is impossible to think of the rule of law in isolation from other values, right? Some theorists take those thick conceptions of the rule of law to include a connection between the rule of law and democracy. Here we're talking about an intrinsic connection. We're talking about a connection that has to do with the very nature of the rule of law. So as you can see, there's a clear distinction between the thin conceptions of the rule of law, such as those advocated by someone like Joseph Raz, where the rule of law is simply a matter of procedure, it has nothing to do with democracy, nothing to do with human rights, it's just about the procedures by which we make law. And those thick conceptions of the rule of law, where the rule of law is linked, it's connected with principles such as democracy and human rights. And I have here a very, very interesting quote from someone that probably all lawyers educated in England or near England know, Lord Bingham. Lord Bingham here, he is rejecting Raza's approach to the rule of law. And he says that instead of Raza's approach to the rule of law, he prefers a thick definition, embracing the protection of human rights within its scope. A state which savagely represses or persecutes sections of its people cannot, in my view, be regarded as observing the rule of law, even if the transport of the persecuted minority to the concentration camp or the compulsory exposure of female children to the mountainside is the subject of detailed laws duly enacted and scrupulously observed. So what Lord Bingham is saying here is that it's absurd to talk about a state of the rule of law where human rights are violated. It's just meaningless. It doesn't have a logical meaning to talk about the state of the rule of law in isolation from discussion about human rights. So I think this is a very useful distinction to have in mind, because in my view, this distinction plays an extremely important role when we try to think about what we understand as a legitimate system, right? A legitimate system that is a system that we identify as justified and correct, and a system to which we feel that we owe our obedience, right? So I think that these conceptions are extremely important to have in mind. Would anyone like to say anything on those or comment on those, or any questions about this kind of introductory stage of the discussion? Okay, let's proceed then. So, for the purposes of what I'm going to discuss today, in my view, we should opt for a thick conception of the rule of law. And in particular, in my view, we can only meaningfully understand the rule of law within the context of democracy. So in my view, we cannot talk about the rule of law without talking about democracy. And the reason is this. So I'm going to be quite brief here because I don't want to get into too much detail and digress. But my position is that when we think about the rule of law, what we essentially think about is a bulwark against political abuse. To my understanding, the rule of law is essentially what protects us from the exercise of political power that is illegitimate, that is abusive, that infringes on our freedom, and so forth and so on. So in my view, the rule of law carries out that function. It's a protection. It is something that prevents abuse from taking place. And now if we think about that abuse, if we think about political power and how we can guard ourselves against the exercise of political power, I think that we are logically led to democracy. Because if we ask ourselves, how can we make sure that political power that is exercised over us is not abusive, is not arbitrary? The solution, the answer we would posit is, well, you can make sure that it's not arbitrary if you've had your hand in carrying out that power, if you had some contribution towards the carrying out of that power, if you had a role to play in the use of political power. This idea of playing a role in the use of political power is, I argue, the essence of democracy. Democracy is the idea that you participate in one way or another to the use of political power. So if you live in a political community and you want to enjoy individual freedom, that is, be independent of this abusive or arbitrary use of power, making sure that no one can come into your home at 10 o'clock at night and seize your possessions and lock you in a room, right? The way in which you can protect yourself, guard yourself against that, is indeed by having some role to play in the use of political power. Now, of course, we can talk about practical limits to that and problems with participating in the use of political power, which would lead us to talking about representative democracy and the use of democracy, institutions of a democracy, and so forth. But I don't want to get into that now because I want to talk about the rule of law. So what I've said so far is simply to portray how, in my view, the rule of law and democracy are not two distinct concepts, but are instead linked together. That when we talk about the rule of law, we are essentially talking about democracy. And this is an idea that we can see very vividly, I would say, in Aristotle. Right? So Aristotle takes this view of the rule of law being contrasted to the rule of men, as he puts it. Right? So we have the rule of law representing reason and rationality being found in collective deliberation, where everyone comes together and think about the law. And on the other hand, we have the rule of men, which is essentially someone telling you to do something upon threat of punishment. Right? So for Aristotle, this is the core distinction, and it is from this distinction that I think we can it is this distinction that I think leads us to this view of the rule of law as being part and parcel of democracy. So you may disagree with that, right? So you may think that what I've said is incorrect, and that's absolutely fine, right? In fact, I do welcome disagreements. One other thing that I want to say about the rule of law is I want to link what I'm doing here with what has been discussed yesterday and this morning, right? The rule of law has different conditions, different elements to it, right? And the rule of law has to do both with the process through which law is made, and it also has to do with the relation between a citizen and justice in its political community. So when we talk about the rule of law, of course, we also talk about judicial independence. And of course, we also talk about impartiality of the judiciary. Because these are what we might call, as Jeremy Waldron calls them, due process elements of the rule of law. Right? Those are, of course, there when we talk about the rule of law. Indeed, we can't really think of a democratic state that doesn't have an impartial judiciary, that doesn't have an independent judiciary. In fact, we tend to associate politicized judiciaries with non-democracies, with autocracies or dictatorships or whatever. So when we talk about the rule of law, my suggestion is that we should think about these due process requirements of the rule of law: judicial independence, impartiality of the judiciary, right to access courts, and so forth. But we should also think about the connection between the rule of law and democracy and democratic elements. Now, let's move on. What about the courts? What I want to discuss today is the role of the courts within a democracy. One could think of the courts being institutions where the rule of law is upheld. And one can think of the courts as being institutions where rule of law conditions are satisfied. Right? One could go to the court to have some interest protected, or one could go to the court to find justice in their case. And we do think that courts are necessary for a democracy. But what I want to discuss today is about possible functions of the court that should cause us to pause and think about the role of the court within democracy. I'm going to talk quite a bit today about judicial review. So a large part of what follows is about judicial review, and it is about the role of the courts that practice judicial review within a democracy. I'm going to say more about judicial review in a minute, what it means, how it works, and so forth, so bear with me on that. Before we proceed, is there anyone who'd like to ask something or say something or comment something on what I've suggested? Is everything clear on how this fits with what has preceded? Yes?
I have a question.
Yes.
When it comes to the rule of law, there was doctrine and the Bingham.
Mm-hmm.
So isn't there a middle ground between the two? Because I believe that there's things that must not really change and things that must be procedural. But there's as well definitely human rights and things that Lord Bingham as well emphasized upon that are very useful and crucial in democratic society. But isn't there like a middle ground merging between the two doctrines?
A middle ground between thin conceptions of the rule of law and thick conception of the rule of law.
Adopted by countries.
Could you
Adopted by countries.
about?
Adopted.
Adopted by different countries. Okay, so a few comments here. First, what I've suggested here, it's not necessarily something that countries adopt, right? In my view, countries in practice, they take a more mixed approach, right? So in many cases, they look at the rule of law like procedural requirements. In my view, that's the case with many Court of Justice cases, Court of Justice of the EU. They focus on those procedural elements, and that's fine, right? I'm not saying that this is wrong, right? I'm not arguing against this approach. What I'm saying is that, in my view, there's more to it than simply that, right? So that's the first comment. A second comment might be that I don't necessarily think that it's... so I don't think that those adopting a thick approach to the rule of law reject the fact that there are procedural elements to the rule of law. Yeah?
Yes.
So I do think that they would agree that there are procedural elements to the rule of law, but the difference is that they would see those procedural elements as being intrinsically linked with some other value, either democracy or human rights or something else. Right? So it's not necessarily either you believe that the rule of law encompasses procedural protections, or you believe that the rule of law dissolves into democracy. I don't think this is the case. Right? So I do think that, well, that's why I mentioned that those procedural elements of the rule of law are still important, right? And they're not to be downplayed. In fact, concluding this presentation, I'm going to argue that we have to look at those first before we proceed and talk about the proper role of the courts and so forth. Does that make sense?
Yes, it does. Thank you.
Okay, so where were we? Good. Now we can start with that. Okay. So let's think about courts. And let's start with a very, very straightforward case. We have two parties, A and B. A and B enter into a contract. According to the contract, person A will provide person B with some services. Person B receives those services but refuses to pay. A sues B for breach of contract. The case goes to court, and the court awards damages. Right? A very straightforward case. What we have here is an example of the court delivering on certain interests, certain rights that are provided to citizens by law. Right? The law of contract says that if you enter into a valid contract, then you have a right to enforce that contract, and if that contract is for one reason or another breached, then you're entitled to certain damages or whatever other benefits the law might get you. So this is a very straightforward case of the role of the court within a democracy. Yeah, in fact, I don't think we can think of a legal system that doesn't have a court to perform this function. So let's move from the uncontroversial to the slightly more controversial cases. And I'm going to deal with a couple of US cases. The reason why I'm going to deal with US cases is because in the US, courts have what we call a strike down power. It means that the Supreme Court of the country has the power to invalidate decisions emanating from the parliament according to the procedures because they violate some part of the Constitution. So there are two cases that I'd like to talk about here. The first one is a case that I think most everyone has probably heard at one point or another, especially if you're in the law department, but not necessarily, and that's Roe and Wade. So what we had in this case was a law that restricted abortion. The case was brought to the Supreme Court, and the court decided that actually this law that emanated from a particular state parliament, following a particular state procedure, the court said that this law actually contravenes a woman's right to privacy. And they cited the 14th Amendment of the Constitution, which reads that nor shall any state deprive any person of life, liberty, or property without due process of law.
Privacy.
Yes.
Not private life. Privacy.
Yes, the right to privacy. The right of privacy does not appear in the US Constitution, but it is read into the 14th Amendment. Right? So the Supreme Court interprets the 14th Amendment so as to include the right to privacy. So what do we think of this case? I'm pretty sure that everyone has an opinion on this. So what do we think? First of all, do you think it's correctly decided?
It's what, sorry?
Correctly decided. Do you think that the Supreme Court did well in this case to invalidate a law restricting abortion?
On the ground of privacy.
On the ground of privacy, yes. So what do we think? Correct, incorrect, good decision, bad decision?
For me, good decision.
Hmm?
It is very subjective.
It is?
It is very subjective.
It is very subjective. Why do you think it's subjective?
Yeah, it depends on the value, on the religion, on the education, and bringing up the place where someone was brought up, the family, and many issues play here a role.
Good. Stephanie, you said that you agree with the decision?
Yes.
Okay.
I agree with it legally, but subjectively, I believe that it has to do a lot with the values of the person.
Has to do with the values of the person. I think that plays into what Danuta suggested, right? That we have different rights, different interests involved here.
I agree with it because I agree with the eventual outcome. So I take a functional approach.
Okay, so Stephanie adopts a functional approach, saying that this is a good decision because the outcome, right, effectively outlawing restrictions to abortion is a good outcome, a morally good outcome, we might say, right? And something I assume you would say a political system should offer this particular right. Yeah,
exactly.
Good.
A democracy, a democratic system.
Good. A democratic system should provide that. And Joya and Danuta, both of you said that this is a very subjective question.
Yes, I do understand that the judge must be objective and must decide in an objective way and must take a decision that will be acceptable to the majority of the society. And that's why I understand it, that the position of an individual It's different.
Okay, so what you are saying is that the judge should take a position, but according to what you said, that reflects the majority of the people, yeah?
Yeah, the majority, but in a positive way, you know, that complies with the values, with the basic values, fundamental values, with constitution, with all the rights, that respects, you know, what is written in the constitution, in organic laws.
And do you think that this happened here, in this case? Difficult case, isn't it?
Yes, it's difficult.
It's a difficult case.
It was 1973.
1973, yes.
Yeah. It's about the same time as this discussion took place in France, more or less.
And in England, incidentally. In the early 70s with the Abortion Act. We'll talk about that in a minute. Okay, so this case, I mean, from what you've suggested, represents a case where we think it's a controversial case, right? We think that there are different rights involved, right? Typically, the debate is between the right to life and the right to privacy, right? The right of a woman to choose what happens with her body, and arguably the rights of the unborn child or fetus. I want to get into that discussion because it also has a legal component. But overall, there appears to be some kind of hesitance when it comes to this case, right? Some uneasiness. Now let's talk about the second case. This case is a little bit older, not that older, and it's the Lochner case. Incidentally, I should mention that Roe and Wade is still good law in the US. It's still applied. We'll see for how long with a conservative majority in the Supreme Court in the US, but it still survives as good law. The case we're going to discuss now has been overturned, so it's no longer good law. The second case, Lochner and New York, you might not be as familiar with this as the Roe and Wade case. So what we have in this case is we have New York legislation which provides some protection for workers. Remember, this was back in 1905. And the legislation is older than that, right? It's late 1800s, early 1900s. So we have legislation, again, by the state legislature. We have legislation that provides protections for workers by limiting the hours that they could work in a single week. The court found that this provision was actually unconstitutional. And the reason why it was unconstitutional is, yes, you guessed it, the 14th Amendment, the same amendment we talked about earlier. In this case, the court held that the law was an unreasonable, unnecessary, and arbitrary interference with the right and liberty of the individual to contract. So what we have here, in other words, is the state legislature issuing a law protecting workers, and the court decided that this law it goes too far because it doesn't allow for the freedom of parties to contract. In this particular case, what we had was a bake shop. And it was a baker who broke the law by having people work in his bakery for longer hours than those allowed by the legislation. So, what do we think about this case? Good decision, bad decision? A bad decision. Why? Freedom of contract, that's a good thing, isn't it?
Yes, but that's over limiting the working hours of workers.
So, and that's a bad thing. Why?
If they want to work more, right?
Yes,
What if they need and they need the money they want to work more?
but maybe it will lead to slavery. So they are working more and paying more, or not just working more?
I mean, back in the 1900s, people who worked in bakeries were paid pennies. It wasn't, a huge wage, right? Yeah, of course, they were paid according to the hours that they worked.
By the hour.
Yeah, but it was not a lot of money.
Okay, we were paid by hour. I thought that they were letting them work more without paying them more.
No, I mean, they did pay them more, right?
Yeah, but it's paid.
So what do you think? Does your opinion change now? Do you think it was a good decision?
Yes.
So you think it's a good decision now? Anyone else?
I mean, it depends as well on the philosophy, on the political
Political culture, we might say.
Political culture, because there are some principles that are saint, I would say. For example, in French law, right to property, it is saint principle, and the same freedom of contract, it is the principle, it is meta principle, it is fundamental principle, and it overrules all other, principles, rules.
So you think that this case was correct within the American context because they put additional value to this freedom of
Within
contract?
the American context, yes, political, philosophical, but it is not, from my point of view.
But you disagree with the decision?
As an individual, I'd like to be protected, and I know that I will not be protected until this
Good.
case. That is the point. That from my individual point of view, it is not good. But in the United States, I mean, the values, are different.
Good.
The way of life and the way people perceive life, they live their lives, and what aims they do have, and they are brought up as well, because they are brought up with these liberal principles, individualistic principles, and in this
Good.
case, yeah.
Okay, no, that's fine. That's fine, right? So, what I take it we have here is again some uneasiness, right? We're a bit unsure about the decision because on one hand, yeah, freedom of contract is good. If you want to get paid and you are able to work, then why not being allowed a couple extra hours per week? On the other hand, we tend to think that within workplaces, or better yet, workplaces are environments of exploitation because there's great imbalance of power, right? What if you have the baker in our example who essentially takes advantage of the workers, overworking them deliberately or pushing them into working more and more and more, which of course has implications for their health and their life and their family life and so forth. So, these two cases are, I dare say, a bit more controversial than the first one, right? So the first one was very, very simple, right? It was quite simplistic, really. It was about how the courts, they serve a particular role, they protect rights, and it's clear, and that's the case, and good for the courts. But what we have here are cases where courts take a more controversial approach. They make a decision that, leaves us questioning them. We don't know, is it the right decision, is it the wrong decision, right? The reason why we think about these cases in this way is because, first of all, they represent a case of judicial review. Right? Judicial review is the process by which a court invalidates or reviews or scrutinizes, eventually invalidating if there is strike on power, scrutinizes decisions by a parliament, by a democratic body. Countries that have the strike down power, such as the US and Germany here in Europe, in those cases we have the courts having the power to actually invalidate a law. The court saying that, this particular law by the state of New York is unconstitutional and invalidated. And that's it, right? Both of these cases are cases of judicial review. In both of these cases, we have the Supreme Court taking a decision that frustrates the decision of a democratic body, that overturns the decision of a democratic body. In the first case, in Roe and Wade, we felt a bit more comfortable about the court having that power, right? Maybe because, as Stephanie put it, simply on a functional basis, right? It's a right that we think it's worthy, and so we are willing to say, Roe and Wade, that's a good decision right there, right? You have a decision where the rights of women, the right of a woman to privacy has some value and should be protected against encroaching legislation. On the other hand, with Lochner and New York, we weren't really in agreement about this particular law, right? Johnny, even you at first, you thought that this decision was a bad decision, right? And Danuta mentioned that a law like this could endanger people, workers, and the rights of people, and so forth. So, where do we stand with judicial review? I think it's quite clear from cases like Roe and Wade that we can think of judicial review in a positive light, right? And indeed, and indeed, we could say that, yes, judicial review is a process by which individual rights are protected. In Roe and Wade, it was the right of a woman to have control over their body. What I want to argue today is that there are some intrinsic problems with judicial review. There are problems when we look at judicial review within the context of democracy. I'm not going to conclude by saying that judicial review should never be used, right? But I think that we should be very careful when thinking about judicial review. One thing that I want to point out, given that we are indeed an English university, is that judicial review in the UK has a kind of a different meaning, right? In the UK, first of all, there's no strike down power. It's not possible for a court to invalidate a decision by the Parliament. However, after 1998 and the Human Rights Act, it is possible for a court to issue a declaration of incompatibility. So it is possible for a court to review legislation and say that, as a matter of fact, this particular piece of legislation is incompatible with the human rights protected by the Convention, and therefore action ought to be taken. Note here that the court, when they issue a declaration of incompatibility, they do not invalidate the decision, right? The decision remains. It's just that it's easier for a minister to take action to amend it. And I should also point out that in the UK context, before 1998, judicial review was mainly looked at as a process to review the actions of executive agents, right? So when there was a minister or another executive agent exercising their power, a court would review the legality of that action. That's what judicial review means. Of course, judicial review still means that today, right, because judicial review entails the review of actions by the executive. But throughout this discussion, I'm going to talk about judicial review as a process by which we, meaning the court, reviews a decision by a democratic chamber, because I think that's where the problems arise. Right? I don't think there's a problem with a court reviewing the legality of the decision of an executive agent, right? Whether or not the decision was according to law and so forth and so forth. But I think that there may be problems with the review of legislation that was enacted by a democratic chamber. And what I want to do now is turn to Jeremy Waldron. Jeremy Waldron is a legal philosopher, And he is, well, the most famous, or one of the most famous thinkers against judicial review. And among other things, Jeremy Waldron wrote an extremely interesting article called "The Core of the Case Against Judicial Review." This article explains what the problems of judicial review are or might be within a democracy. This is what Jeremy Waldron does. And I'm going to give you the nutshell version of that argument, of what Waldron is suggesting here. What Waldron is saying here is that judicial review gives judges power to invalidate decisions by democratic assemblies. This means that the will of the people that was supposed to be expressed from a parliament or from an assembly, a democratic assembly, cannot make law. It means that the will of the people is not expressed in this case. Judicial review, therefore, is a process by its nature that is against democracy. Why is it against democracy? Because it always targets the decisions of a democracy. And the court itself is not a democratic body, right? We have unelected people, experts, right?
So-called anti-majoritarian body.
Exactly.
And it is not democratic. 9 people sitting in Supreme Court of the United States, 9 people, and
Yes.
the votes of 9 people, and we have 250 million.
Exactly.
Decide, what is good for 250 million, and 9 people which are elected by the President of the United States.
Good. So that's kind of Waldron's point. Waldron's point is, how democratic is it to allow those 9 people who were appointed to that post, right? How democratic is it to allow them to go against the democratic law? Go ahead.
But someone needs to decide. So 250 million people cannot decide because chaos will occur and then there's conflict. But those 9 people are judges. They must cope with cases with transparency, objectively, so on and so forth, according to the law, the constitution. So why are they undemocratic?
Okay.
Let's say that another thing to add, they are elected by, it is a political decision.
They are?
They are elected by a political decision.
Good.
These are political guys. They should be independent of politics, but they are not.
But they lack accountability, right?
Yeah, but they should have breaks. You know what you refer to. We need these people because we need someone to decide for difficult cases, but they should be breaks. And these breaks are in constitutions. These are the fundamental values, moral values, ethical values, but as well, the culture. The right to privacy, the freedom of contract, which is safe in the United States and prevails. And they should be led in their decisions by positive, fundamental human values as breaks to their decisions, not to be arbitrary.
No, let's get to that, because Waldron talks about all of this, right? Waldron's position is by no means the norm, right? Most people, they tend to think like that. No, we do want a court to decide whether or not a law goes too far on the basis of human rights or on the basis of a constitution, right? And we'll get to that in a minute. But before we get to that, Joya, I want you to think of it a little bit differently, right? Let's say that you live in a political community and there's a law telling you to do something. One question that you ask yourself, or you ought to ask yourself, and all of us should ask ourselves, is why should I obey that law? Right? Why do what the law says? Of course, the easy answer, the straightforward answer is because I don't want to pay a fine, or because I don't want to go to jail, or because I don't want to be indicted, I don't want to go to court. It's a hassle, it costs money, it costs reputation, and so forth. Right? So that's fine, right? Those are indeed reasons why people obey the law. But that doesn't mean that every time you know there's not a police officer there, you break the law. Right? So there are reasons beyond those self-interest reasons why you obey the law. And if I were to ask you why do you obey the law that comes out of the Cypriot parliament, and you don't obey the law that I pronounce by stepping on this chair, right? Your answer would be straightforward. Right? Your answer would be, well, they have legitimacy. They are a democratic body. I vote for them, right? I participate in the process of giving them power, and I allow, in a sense, their use of power in that way. Sure, I don't agree with everything the representative says, but as an institution, as a body, yes, I do agree with that parliament. And I do think that it has legitimacy. That's probably your answer, right? Otherwise, I'll step on this chair right now. But, so the idea is that democratic legitimacy matters. It matters to our everyday lives. It matters with how we think about our life within a community. And if that matters, then we should ask ourselves, well, why? If I am the subject of a decision like Roe and Wade, why should I agree with the court? Why not say that, no, why listen to the court? Why did they get it right? I mean, we talked about we're not sure if they got it right. Yeah? So the question becomes, well, why? In the case of a democracy, right, you might disagree with the decision, but there's an answer to the why. Right? You say that, well, I disagree with that decision. I think it's unjust, I think it's unfair, I think it's illogical, but democratic legitimacy means that I'm going to obey it. And then we have a decision like this, where again, you think it's unjust, it's unfair, it's illogical, or you might think that it's unjust, it's unfair, it's illogical. And you need to ask yourself, once again, why should I obey a decision like this? That's the problem that Waldron identifies. And Waldron is saying, incidentally, because he talks about Roe and Wade, right? One of the things that Waldron is saying is, he is asking us to juxtapose the case of abortion in the US and the case of abortion in the UK. The case of abortion in the US has been an ongoing problem since Roe and Wade. Since Roe and Wade, for every single election, for every single presidential election, for every single election for the Senate and for the House, politicians are asked about whether or not they would help overturn Roe and Wade. For every single election. In the UK, it was an issue, right, back in the 60s. And what we had was a parliament coming together and working out a legislation. And having the Abortion Act, 1967, I believe, that resolved the issue once and for all. If you're in the UK today, you will not listen to a single politician talking about abortion. Not a single person. The reason is this. For Waldron, judicial review is the wrong way to make decisions. For Waldron, judicial review is a poor way to resolve these questions. Right? Now, you might ask yourselves, well, why is it such a big problem? I mean, we have Roe and Wade. Roe and Wade is a good decision, or at least we might think it's a good decision, right? Why is it such a problem? In fact, what the courts do when they strike down legislation is they apply the Constitution. They interpret the Constitution, they apply the Constitution. They rely on the rights that the Constitution provides. So why should it be a bad thing? Why is it a bad thing? It isn't a bad thing when we have a case like this, right? This is not a bad thing. We want the court to make a decision here. So why is it an innocuous thing here? Why is it no big deal here that we have a court making a decision affecting people's lives? And it's a huge deal here. Well, Waldron's answer is this, and it's something that both of you touched when we first talked about Roe and Wade. Waldron's answer is that we live in a political community where people have different interests, different beliefs. And so what Waldron is saying is that there will always be a question of political disagreement. In a case like the first one, the reason why this is not a problem is because it's a clear case of an interest being breached. It's not a balancing exercise here. But what we have here is very much a balancing exercise. What we have in those cases what we have in all cases of judicial review are rights that pull to one direction against rights pulling to another direction. What we have in Roe and Wade, and the reason why we agree it's a controversial case, is because we have certain interests, the interest of a woman to her body, and then we have other interests, religion, the right of the unborn child, and so forth and so forth. So we have different interests pulling in different directions. What Waldron is saying is that in those cases, in those difficult cases of judicial review, why should we think that the judges should do this balancing exercise? Why should it be the judges? And this goes back to something Danuta said earlier. You said that judges should make decisions on the basis of what the majority of the people want, right? Or what the interest of the majority might be.
As I said, what would be acceptable, not only the interest or what they want, but what could be acceptable for the majority. Because we are in democracy, in democratic state, democracy and majority rules, and it is one of the elements that the judge takes into account.
But the question is, why not leave it to the Democratic Assembly to do that? What you're describing is the process of a parliament. That's what parliament is supposed to do. A parliament is supposed to consider what the people want, right? What is correct, what is just, what is morally right in what the people want, and make a law based on that.
My answer is to me personally. There are some areas they touch people's lives so deeply. I wouldn't regulate them. I would leave them to individuals' decision, individuals' spirit, individuals' education. Because they are very, very difficult. Because on the one hand, we have rights of a woman, but on the other hand, we have the right of an unborn child.
Well, that's absolutely fine. What I'm saying is, why should it be the court making that decision you're describing there? That's what Waldron is saying.
Because maybe Parliament, they do not want to take responsibility for this, and they do not regulate it.
But shouldn't we have the Parliament decide those things precisely because we want to keep them accountable? Right? Because when judges in Roe and Wade made a decision, right? Maybe some people disagree with that decision. Those judges were not subject to accountability. Right? They were not subject to removal from office because of election. They were not subject to popular opinion. Right? So the question is, if we want to say we live in a democracy, and if living in a democracy means keeping those making decisions accountable, then why would someone accept handing over those decisions to a judiciary? right? That's Waldron's point, right? Now, how can we reconcile Waldron's point, which indeed appears to be against a robust role for the judiciary in a democracy, with populism? And yesterday we talked about that quite a bit, right? We talked about this picture from the Daily Mail with the judges being portrayed as the enemies of the people, right? And the idea behind this front page is that we have the people with certain interests, and then we have the corrupt elite who frustrate the interests of the people, who go against the will of the people, right? So one might be asking, is Waldron giving us something that populist parties are using, right? Is Waldron's idea that judicial review or courts in a democracy could act in ways that are against democracy, is this an argument used by populist parties? Or is it an argument that populist parties might use? Because in their attacks against the judiciary, populist parties, they do talk about democracy. They do say that the courts are elitist. They are the instruments of the ruling class, and we are the people, and we want democracy, so let's go against the courts. Let's pack the courts with people, with judges who are going to push forward the popular agenda. That's what populist parties are saying. Now, it would be thoroughly unfair to Waldron were we to do that. The reason why it would be unfair if we were to do that is that when Waldron makes the case against judicial review, he has certain assumptions. And he is saying that my argument against judicial review only applies in certain states. It only applies for certain political communities that are democratic, that they generally protect human rights, that have an independent judiciary, and that are interested in protecting individual rights. So what Waldron is saying is that first we need to satisfy those assumptions. First, we need to make sure that we're talking about a political community which has an independent judiciary. We're talking about a political community that has human rights protections, and then we should look at questioning judicial review. So in cases of countries run by populists, Waldron would simply say, well, the assumptions are not satisfied because you're not looking at a country that has an independent judiciary. You're not looking at a country that has a good track record of protecting individual rights for minorities. And you're not looking at a country that has the political will to protect human rights. So Waldron would say, let's fix those assumptions first, and then we can move on to discuss whether or not judicial review is compatible with democracy. So Waldron wouldn't be against the use of judicial review in, let's say, a populist country, right? Because he would think that a populist country does not satisfy those assumptions. Does that make sense? Yes? Excuse me. Any questions or comments before we proceed?
Actually, just from the very beginning, I wanted to say that we have to take into account that we are dealing with different systems. We have a continental system and common law system, and these are different systems. Where law in continental context, it is law in books, and that does not have this room of maneuver. It is not big, especially in French context. But in the common law countries, now it changes. There are more bills. There are more laws. But
more codification.
Yes, but before everything was decided, or mostly everything, by courts, and courts were
exactly.
And that's why it is this law, and that's why from our European continental point of view, okay, we say, okay, it should be a democratically elected body. We should have first law, and then on the basis of law, court decides. But in the American context or common law context is different. There should not, there does not have to be law, because very often there is no law. I said it changes now because there is law, no law is issued. But there does not have to be law, and court decides, judges decide. Without having no will as such. It is the context is different.
Good, that's absolutely right, yeah? So yes, the context matters here, and when we talk about common law countries, it's easier to see those cases being played out. But
acceptable for Americans when they say, okay, it is done by a judge, they will accept it. For us, if there is no law, for us Europeans, I mean continental Europe, if there is no law and then judges decide on the basis of what, it can be questionable, you know? And
yes, no, I do agree with that, but bear in mind that all of these cases, even the case from the US, they're relying on a constitution. Right? They're not making decisions in the abstract. And second thing is that even though you're correct about this distinction between common law and continental law, Germany has a strike down power for the constitutional court. So it can read the constitution and invalidate a law. So the problems that I'm describing here in terms of, well, how democratic are truly the courts, they would arise in those cases as well. Okay, so what might be a problem with Waldron's account? For this last part of the workshop, I want to offer something that I think undermines Waldron's account, and then I'm going to proceed with talking a bit more briefly about some other arguments that can be used in favor of judicial review. And so against Waldron's argument against judicial review. So in my view, one thing that might be wrong with Waldron's account is how the standard of legitimacy Waldron uses is that not only of a democracy, but of a majoritarian democracy. So for Waldron, the standard to decide if judicial review is good or bad is whether or not it's democratic. And to decide the question of what is democratic, Waldron talks about the principle of one person, one vote. Right? The idea that if we want to look at democracy, we must look at majority voting. That's the essence of democracy, according to Waldron. In my view, that's incorrect. Right? So I think that Waldron here is talking about a majoritarian system. A majoritarian system is indeed a system where whatever most people want, that's the will of a democracy. But that's not really all there is to it, right? If 50% plus one of the population decides that they want to enslave the 49%, then that's not the will of the majority working, right? So when we talk about democracy, I think that there are more conditions for legitimacy rather than simply majoritarianism, right? So I think that we should think about what democracy is, not simply in terms of whatever most people want, but also in terms of whatever most people want, but also what improves opportunities to participate in politics, what does not diminish access to politics, and so on. So I think that this is something that we can think of with respect to Jeremy Waldron. One of the most important persons who argued in favor of judicial review is Ronald Dworkin. Ronald Dworkin is perhaps the most influential legal and political philosopher in the Anglo-American context in the last century or so. He passed a few years back. And for Dworkin, judicial review is the ultimate protection of human rights. Courts when they engage in judicial review, when they overturn decisions by a democratic assembly that undermine human rights, they are not undermining democracy, they're actually improving democracy. Why is Dworkin saying that those decisions improve democracy? Because for Dworkin, democracy and human rights are interlinked. Democracy is all about protecting everyone's human rights. So for Dworkin is able to say that, you know what, courts, when they have a case in front of them, courts act as forums of principle. For Dworkin, courts make decisions on the basis not simply of rules, but also legal principles. And those legal principles they come from the community. And so for Dworkin, if we are to talk about a democracy, we must talk about human rights. And therefore, if we're talking about a judicial review decision that protects human rights, then you're talking about a judicial review decision that also protects democracy. Does that make sense? Yeah? So the main difference here between Dworkin and Waldron is that, the main difference between Dworkin and Waldron is that they have completely different views of what democracy entails. This, of course, leads us back to the initial discussion we had about the rule of law, where the rule of law includes protection for human rights or includes democratic principles and so on. So here with Dworkin, we have a person who takes a very different understanding of what democracy entails. Democracy entails the protection of human rights, and therefore a decision like Roe and Wade that actually protects human rights, protects the rights of a woman, right? That decision is a good decision that is conducive to democracy. Does that make sense?
It does, but sometimes human rights conflict with each other.
Good. And this leads to another idea of Ronald Dworkin, but there's one right answer. In decisions in courts where we have a conflict of different rights, Ronald Dworkin's theory is rather complex, right? So if you take classes like Thinking and Arguing Law or Jurisprudence, we're going to talk about this in class in more detail, but what Ronald Dworkin is saying is that courts should act on the basis of legal interpretivism. Interpretivism is the idea that every time a case reaches a court, the court must look at legal history and make a decision that best fits that judicial history based on all those legal principles and so forth, but also a decision that puts the overall system in the best possible light. It's what he calls the fit and justification way of making law. So for Dworkin, in a case like Roe and Wade, what we have is a judge faced with a complex decision, a matter of weighing different rights, and according to Dworkin, what that judge should do, or did, was consider different interpretations and opted for the interpretation that puts the legal system in its best possible light, right? Of course, that includes protection of human rights and so forth, because for Dworkin, those are fundamental for a legal community. And so this is what happened here. So Dworkin proposes a very different approach to judicial review than the one proposed by Jeremy Waldron. Now, ways to criticize Dworkin, well, again, this goes back to a difference between what I call here process-based and outcome-based models of legitimacy. So for Waldron, legitimacy is about the process. It's about securing a democratic process. Whatever the democratic process decides, that's good law. For Dworkin, on the other hand, it's all about the outcome. It's all about reaching an outcome that protects human rights. That's what's legitimate. So for Dworkin, if a decision indeed manages to protect human rights, then that's a good decision right there.
Yeah, and according to Waldron, what would be the answer in the case of law versus anyway?
For Dworkin?
For Dworkin, it would be in favor of a woman or in favor of an unborn child?
No, I think I'm not sure what Dworkin said on that particular point, but I'm pretty sure that he's in favor of allowing the right of abortion, right? Now, one other thing that I want to say here is this. Dworkin has a clear view of what is legitimate. Legitimate is what protects human rights. So the outcome must be something that protects human rights. One thing that one might object is, well, why leave it to judges to decide what protects human rights? Why judges? In order to understand this question, I suggest that we look back to Plato for a minute here. Because Plato, in his Republic, I think it's the 8th book, but I might be wrong. So, in the Republic, Plato offers one of his usual ridicules of democracy, attacking democracy because it's a bad system. But in the course of doing that, Plato identifies what he calls titles to rule. Essentially, it's the discussion we had earlier, right? The use of political power over us. Why would someone be justified to exercise political power over you, right? And Plato offers 7 different titles. I'm not going to bore you with the details with all of those titles. I instead want to focus on the 4th title. The 4th title is what Plato calls the title of wisdom. Plato is saying, yes, you should do what someone else says when that someone else has supreme wisdom, supreme skill, supreme experience, when they are better at you at reaching at a decision. Right? Of course, that in Plato, this culminates into the overwhelming role of the philosopher ruler, right? Those philosophers will decide for everyone because they know best. But for our purposes, I think it's useful to think of this title of wisdom. Because what we're looking for in our communities is essentially, even if we don't recognize it immediately, is essentially we want good decisions. We want wise decisions, but at the same time, we want decisions that come from a process that respects our role as a member of the democratic community. And these two can become difficult to combine. Indeed, for Plato, they cannot be combined. So judicial review could be seen as a process where we have some people, because they have superior wisdom and skills and expertise, making decisions, deciding on what's the right answer here. Of course, Dworkin rejects this view, right? Because Dworkin is saying, according to the authority of the courts, the authority of the courts does not hinge on our trust in their skill or expertise or moral knowledge to decide rights issues. It instead flows from the service they do to democracy by protecting individual rights against abuses. If they stop providing that service, that is when they make a mistake, they fail democracy. So you can see the difference between these two viewpoints, right? If we trust the courts because they have wisdom and expertise and so forth, then we need to also accept their decision in Lochner. But instead, if we follow what Dworkin is saying, right? And Dworkin is saying that, no, it's all about the outcome. It's all about whether or not they protect human rights in the best possible way. Then we would simply say that, okay, here the court failed democracy. Does that make sense? Yes? Doesn't have many questions or anything that's unclear here.
No, I am just thinking because you were just speaking about Plato and Aristotle, who said that democracy is the worst system. It is not the best.
For Plato, yes, it is.
We are speaking about democracy as the best, but for ancient philosophers, it was the worst.
Well, not necessarily for Aristotle, incidentally, right? Because Aristotle has a more favorable view of collective deliberation.
Monarchy, as far as I remember, it was they pretended monarchy was.
So, yes, in the taxonomy of constitutions, monarchy, according to both Plato and Aristotle, has the potential of doing the greater good, right? They both rejected it, incidentally. For Aristotle, the best possible system is kind of a mixture of democracy with aristocracy, with some aristocratic elements, what he calls a polity, or politia, or the constitution, that's how he calls it in his politics. All right, so let's move on. So this was one argument in favor of judicial review. Another argument in favor of judicial review is to simply say that our systems are not really democratic, right? We like to talk about them being democratic, but they're not really truly democratic. So judicial review is a way to remedy that gap. One example that I have here are the recent elections for the parliament here in Cyprus. In these elections, 34% of eligible voters decided not to vote. So immediately we have 34% of people who were supposedly able to vote, choosing not to vote. And of those 62% who voted, 12.5 voted for parties that did not clear the minimum threshold. So they're not represented in the parliament. So immediately we can see that although we talk about the parliament being a democratic body, a big chunk of the population is not represented. So the idea here is that if our systems are not democratic, then there's no issue, there's no question. Well, who would make a decision? We have a non-democratic body in a parliament, so what's the problem with handing over the decision to courts? I think there's something wrong with this approach. I think there's something wrong with this argument. What I think is wrong with this argument is that it diminishes legitimacy to an all or nothing concept. So according to this account, our systems are not legitimate because they're not democratic, right? But in my view, we can talk about different systems being more or less democratic. So I don't think it makes sense to say that, because a big part of the population was not actually represented in our parliament, we've immediately become North Korea. I don't think that makes sense. I don't think that's meaningful. Yeah?
And that is so unfair because, for example, there is some countries that have a low level of corruption, let's say, or for example, a little bit of I will not say unconstitutional, but like less legitimate parliaments or less legitimate elections, for example, because now the majority does not approve. Mm-hmm. But for example, there's other countries such as my country where everything is so corrupted and so undemocratic. So it's very unfair to say that both those countries are undemocratic.
Good. Good, and I think that's absolutely right. Yeah, I think that we can talk about stages or processes, or you cannot put, let's say, a Scandinavian country in the same boat as a budding democracy. Right? That simply doesn't work. Because a democracy is more than simply having a parliament, right? A democracy is about a specific ethos, a specific democratic ethos. It's about having the resources to support a democratic ethos. It's about having the resources, having money to spend on proper elections, and having money to spend to protect public discourse.
Yeah, and having a civil society and very strong middle class.
Exactly. It's about having a place, a sphere, a public sphere where public discourse can take place uninterrupted, right? That's why you need civil society institutions and mechanisms and so forth. So a democracy is more about simply looking at this parliament or that parliament or this institution or that institution. So in my view, if we can talk about democracy or democratic legitimacy coming in degrees, then of course we can talk about problems with judicial review. Of course we can think of judicial review as something that possibly undermines democratic legitimacy, or pro tanto, taking away democratic legitimacy. Or conversely, if you are someone like Dworkin, say that, no, judicial review actually improves democratic legitimacy. It increases the level of democratic legitimacy. And this is the reason why I think that this argument is not that strong. We're running out of time, so let's skip this. Let's move on to this, because I think this is a very interesting argument. According to this argument, what we should do is bite the bullet. We should simply say, yes, courts are undemocratic. They are undemocratic institutions. But they are a necessary element of a democracy. Courts are anti-majority institutions, but they're useful because they limit democratic abuses. Remember the example that I threw out earlier about 51% voting in ways to undermine the rights of the 49%. The reason why this doesn't happen is because we have safeguards. We have a constitution that is entrenched, that is not amenable to easy change, right? That in and of itself is an anti-majority institution. So the argument here is to say that, yes, our democracies are not simply majoritarian institutions. They are not simply institutions where we let the 51% decide, but instead they're complex bodies that also include anti-majority institutions. They also include institutions that might affect democracy adversely in and of themselves, but they are necessary because they limit the excesses of democracy.
What about countries that don't have a constitution?
Countries that don't have a constitution, such as?
UK.
Well, it still has a constitution, it's just unwritten, right? So the UK still has a constitution because it has a series of constitutional principles, right?
There are some basic organic, so-called organic law, and it is the case of Israel, it is the case of United Kingdom, that there is a kind of constitution. There is not one document, but in different laws, you have written principles.
I mean, in the UK, for example, I don't know if you talked about the Thornton case. In the Thornton case, the court decided that you cannot impliedly repeal the European Communities Act of 1972, right? Why? Because the European Communities Act of 1972 had an entrenched status, a constitutional status, which meant that you cannot simply haphazardly amend it or change it. If you want to change it, you need to really want to change it, which is exactly what constitutions are. Constitutions are documents that contain rights and provisions that, of course, you could change them, but it's really, really difficult to change them, right? There are complex procedures to change them.
Yeah, but in the UK context, the issue was the sovereignty of Parliament. It means that the next Parliament is not bound by the Parliament
Exactly.
by the previous one. And if the Parliament just agreed on this European Act of 1972, and then it was 2011, I mean the next one, then the next Parliament was not bound according to the basic principles, fundamental principles.
Yes, and of course that statute was overruled, right? Was repealed by the Brexit Act that allowed for the exit of the UK from the EU.
Yeah,
Would you like to say something else? Okay, good. So this is one other way to look at it. To conclude, because we've run a bit over, The purpose of my presentation today has not been to dismiss the importance, of course, in a modern state. Right? That has not been my purpose. Indeed, I think it's very easy for us to say that we need strong judicial systems in every single country and also ask questions about the role of the judiciary. What I mean to suggest is that when we look at attacks on the judiciary in Poland or Hungary or France or any other country, of course we should look at them and try to deal with them as robustly as possible. It is by no means what I've suggested here, what I've discussed in Waldron. Waldron doesn't think that attacks on the judiciary are justified. So what I've suggested here is not meant as ammunition for populists in attacking the judiciary. On the contrary, what I've suggested here is we need, as a first stage, look at the due process requirements of the rule of law. We need to look at an independent judiciary. We need to look at an impartial judiciary. We need to look at right to access the judiciary, right to fair trial, and so forth. And once we do that, and once we achieve the sort of society that protects and respects those due process requirements of the rule of law, then I think we can start asking questions about processes like the judicial review, or questions about judicial activism, or questions about the role of the court within a democratic state. That's what I wanted to discuss with you today. I hope you've enjoyed it. Does anyone have any questions, either here in the class or on Microsoft Teams? Anything that you'd like to say, or ask, or comment, or criticize? Anything of the sort?
My one comment is that it is what I read to at the beginning, that we need safeguards, good constitution and good constitutional courts, because these are the safeguards for rights of minorities. And it is one thing, and another is taking into account this, to two systems. It is continental civil law, and common law. By definition, the continental judge, the continental lawyer, is on the side of the state. Because he is deciding on what is written in codex, what is written in books. Okay, he has a room of Monnet, but it is not very huge. But the judge in the continental law is, by definition, on the side of the individual. And these are, and this is something, and this is what here, and in these cases, was at stake. The judge is on the side rather of the individual than on a state.
I think that's certainly one way to look at it, right? I think in cases like Roe and Wade, yes, it is possible to see as the judge acting to protect the interest of the person a bit more creatively, we could say.
Yeah, I don't want to say that judge in continental system does not protect the interest of the individual. Yes, but his rule of Monnet is smaller.
Yeah. So because here in this case it's clear that there is room for creativity.
For creativity.
Yes. Okay. If there's nothing else anyone would like to say, let me stop the recording now.